Structuring a winning case tutorial coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. I'm Jordan Farkas, so grateful to have you. And in today's video, I'm going to talk about how to structure your case to be a winning one in the small claims court. In previous videos, I've talked about various considerations that you need to make before you even enter a small claims court lawsuit, how to build your evidence, etc. In the last video, I said I'm going to talk about an applied tutorial, if you will, as to how it works using a sample case. So that's what I'm going to do in this video, so you can sort of get an idea of how the things I've been talking about will apply in actuality, using obviously a made up case scenario, but that will hopefully give you an idea of how you can take some pointers from this make-believe scenario to apply to your own case. Obviously, everybody's fact scenario of their particular case, whatever you may be struggling with now as you're considering going to small claims court, or maybe you're in the middle of a small claims court lawsuit and you're trying to figure out how you best go about doing it, your fact scenario will be different than the one I'm presenting now, although I'm presenting a pretty common one, which I'll get into in a moment. But the point is that you can take a lot of the principles and apply it to your case. Of course, if you would like to get a kind of case study in a fact scenario involving your case without me giving specific legal advice, but if it's a type of case where I feel that it comes up a lot, because in my years of practice as a small claims court attorney, a lot of the same fact scenarios would happen again and again as I continued to have more clients, and I would see commonalities and similar patterns throughout all of these cases. So if you want me to maybe get into that in a future video, feel free to leave that in the comments section below. Of course, I'm always grateful for your feedback. And also, if you have not subscribed yet, then a great way to not miss a future video is to subscribe and hit that notification bell. And if you have already subscribed, thank you very much for doing that. So without further ado, as usual, if you haven't seen my previous videos, I do recommend that you go back and watch them as well, because those previous videos kind of build up to this one. And if you wanted to get a sense of who I am and you're not a subscriber yet, then on the home page of this channel, there's a little bit about me, a little bio on who I am, my background as a small claims court attorney, the books that I've written on small claims court. If you've already subscribed, then it's probably a different video on the home channel, but you already know more about me if you're already a subscriber. So with that in mind, what I've done here is I've done my usual whiteboard over here. And I know it's a bit hard to read also because my handwriting isn't wonderful. But in any case, what's written here at the top was that we're taking a make-believe case. Any reference to any actual names obviously is coincidental. We're taking a make-believe case of John's Construction versus Jim Smith. So let's talk about what happened and what's been exchanged between these two people. John's Construction, we can say, is owned by John Jones, let's just say. And John Jones had a contract with Jim Smith to provide a new deck, let's just say, to Jim Smith. Jim wanted to have a nice new deck outside his summer home, and he hired John's Construction to do that work. And as part of that hiring, John has a contract that he uses for all his clients, which is always a good idea because contracts are there to protect you. It's also there to protect, it's really there to protect both parties, really, but especially the one who's entering into the contract and doing all that work. You certainly want to have a written contract to be able to show what the agreement was between the parties. Of course, there's all sorts of details that can go into a contract. You know what? I'm going to do a future video on that as well, how to kind of structure a contract, certain types of clauses that should be in every contract. Of course, the YouTube channel is worldwide, as I say in all my videos, so the legalities will differ depending on each particular jurisdiction. But again, there's some common themes that should be included in every contract. So John has a contract with Jim Smith, and the contract is for that deck, as I mentioned, and the agreed compensation, the consideration, to use the legal terminology, was for $5,000. Now, let's add in that there was a completion date. Let's say they entered into the contract on September 1st, and the completion date was October 1st. That's all written in the contract. It also specified the work that John's Construction was supposed to do for Jim Smith and the type of work that Jim Smith wanted. So let's say, for example, Jim wanted certain type of wood to be used for his patio, and John's Construction agreed to that. All that was laid out in the contract for $5,000. Now, what happened was after John started doing the work, Jim Smith decided that he wanted a different type of wood. And so he said to John, hey, I know you've already started, but what if we switch to this type of wood? And what happened was John said back to Jim, well, I can do that, but that's going to change the amount of the contract because it's more expensive. And it's more time because I have to undo some of the work that I already did and put in this new type of wood, which costs more money. And that's going to cost another $2,000, as I've written over here. And Jim Smith agreed to that. So John Smith put in a change order. Now, it's interesting to note that really what should happen in such an instance is that the two parties enter into a revised contract or an addendum, sort of like a supplemental contract to the first contract, to make it clear that there's been a change order. And let's say that they didn't. Okay, so let's say that all this was done via text message. Okay, again, different laws will apply in different jurisdictions. Some jurisdictions will say that those are the types of exchanges that cannot be allowed. But in most small claims court cases, I would say that small claims court is a people's court, and usually text messages exchanges between parties will be allowed. Of course, it will always be within the discretion of the decision maker, of the judge, to decide how much weight, how much credibility to give to these exchanges. But in most cases, the small claims court will allow it. So these text messages are very important, especially for John's Construction, to preserve them and not to delete them, especially because things can go awry, as we'll soon see as what happened in this instance. So there's text messages that demonstrate that there were these change orders in place where John's Construction says it's another $2,000 and Jim Smith writes back, okay. And so the parties continue with the contract and John does the work. And sure enough, he completes the work by October 1st. And John has the foresight to take photographs. Okay, so he's got photos after completion of the work being done to show what the work looked like. Now, ideally, what John's Construction would do is he would have before and after photographs. Very important in order to show the difference between what was there beforehand and what was there afterwards. So John does the work and he invoices Jim Smith to pay him. And all of a sudden, John gets an email from Jim Smith stating that the work you did was shoddy. I didn't like the fact that you did such and such, and I'm not going to pay you anything. Now, there may be cases where Jim Smith says back, well, I'll pay you $3,000, but I'm not paying you the $5,000 or the $2,000 for the change order. So there's all sorts of different fact scenarios that could happen in a small claims court dispute. But let's say this is a case where Jim Smith says, I'm not paying you anything. And he says, the reason I'm not paying you anything is because I got in another contractor, and that contractor said that the work was terrible. And so I hired that contractor to undo your work, and I had to pay him even more. So there could be cases where John Smith will say, not only Jim Smith, well, the defendant, the potential defendant, was the homeowner, will say that not only am I not paying you, you owe me money because I had to pay this other contractor to undo your shoddy work and do a proper job. And so what happens is that, again, Jim's Construction has some foresight to say, well, you know what, I better get in an expert here who can attest to what transpired. Now, that can be tricky, by the way, to get an expert, because a lot of times once the contractor has left the job, the homeowner obviously doesn't let that contractor back in to do the job. And therefore, it can be challenging for, to rely on an expert just by looking at photographs of what transpired. But let's assume that John's Construction had the foresight at the end of the job to say to Sarah's Construction, to Sarah's Engineering, rather, I wrote down over here, to come in, have a look at my work, and can you just confirm that all my work is good? And if I ever need you in the future, you can testify. And that may sound a bit kind of not, or maybe extreme. It's not something that's done all the time. But let's say in this instance, John was kind of getting the sense that Jim wasn't going to pay him. He had that energy, if you will. Jim was kind of making rumblings as he was doing the work. And John says to himself, oh boy, there's some red flags here. I better get in, Sarah's Engineering in order to, back up my story in case this goes awry. And sure enough, it does go awry. And so John's Construction really was wise to have that foresight. So that's the fact scenario. And now where we're at is that John's Construction finds himself in a pickle because he's out $7,000 that he was supposed to be paid. He's out of pocket for the materials that he spent on the patio, and Jim Smith isn't paying him anything. In fact, Jim Smith is claiming that John owes him money. So let's take what I talked about in the previous video with this fact scenario that we have now to understand how John's Construction is going to prepare for the upcoming trial. Okay, so let's assume that John goes ahead and files a lawsuit. He's checked the limitation period, as I talked about in the first video. There's no limitation problem here because it's well within the time that John is allowed to sue. John has considered all sorts of things, such as, does Jim Smith have the ability to pay? Well, he does, because he owns a home, so that if John wins in court and Jim doesn't pay the judgment, he can collect by seizing or putting in some places it's called a writ, in some places is called a lien on his home, et cetera, et cetera. Okay, so there's all sorts of considerations that John's Construction goes through because he watched the Mr. Small Claims Court YouTube video that I did. And now we're at a point where he's filed a lawsuit and he's getting ready for trial. So the first thing I talked about in the last video, and I wrote down here in the corner here in red, is defendant, meaning making sure you name the right defendant. Now, in this case, that's simple because Jim Smith is the one who entered into a contract with John's Construction. So therefore, Jim Smith is going to be the defendant. Now, just to throw in, it's not always so clear cut, because let's say Jim Smith is married to Sally Smith. So arguably what should have happened in the beginning is that Jim's Construction should have probably insisted on both Jim and Sally Smith being on the contract. However, in this case, Jim did not put Sally Smith on the contract, and therefore, because the contract was exclusively with Jim Smith would be the proper defendant. In fact, if John was to name Sally Smith as a defendant, that may be problematic because Sally Smith is not properly named if she wasn't on the contract. Just because she's a homeowner doesn't necessarily make her a party to the contract. Of course, again, this will depend on various jurisdictions, but this is another reason why before even entering into a contract, it's important to get a sense of who the homeowner is, which, as I talked about in the first video, you can do that by all sorts of means of searches. In most jurisdictions, you can do a search of a property to see who the owners are. But John didn't do that. He only contracted with Jim Smith, and therefore that's the one he has to name. Hopefully, the property is not exclusively in Sally Smith's name, because if that's the case, John's Construction really has a problem, because even if he wins the case against Jim Smith, if the property is only in Sally Smith's name, John's Construction may have a problem collecting even if he gets judgment. Okay, getting judgment, I used to say when I was a practicing small claims court attorney, is half the battle. Sometimes the bigger battle, and oftentimes, is actually collecting on a judgment. So it's so crucial to do that research beforehand. But John's Construction did not do that in this case, and that's the case. It is what it is. Jim Smith is the one he contracted with, and therefore Jim Smith is going to be the defendant. One other point I'll mention, though, sometimes strategically, even if Sally Smith was not the contracting party, there may be some wise legal maneuvers that one can make. Again, I'm not advocating for doing anything dishonest, but within the law, sometimes one can argue, hey, Sally Smith is the one who benefited from my work. So even if she wasn't on the contract per se, she is the beneficiary of work that I did, and therefore on that basis, I'm going to name her as a defendant. So don't always assume that all hope is lost just because you had a contract with one party and you forgot to name the other party. Again, small claims court is a people's court, and a lot of times these types of arguments can win the day. But in some small claims courts, if you do name the wrong party and a judge decides that you shouldn't have named that party, there could be cost sanctions against you. In most small claims court, the cost sanctions are not that high, so a lot of times the risk is worth the return or potential return, but these are types of considerations that one must make. And that's another reason why, depending on your jurisdiction and depending on how much is involved, if it's worthwhile from a financial perspective to consult with an attorney, that may be wise to do to make sure you've explored all avenues. In any case, so we've got the defendant named based on who the contract was with. And the next thing I talked about in the last video is the chronology. So what you're doing is you're going through the chronology with the judge. So what John's Construction wants to do, make sure that he does, is kind of jot down, or however he's good at keeping his records, make a record for himself of everything that transpired in order of what transpired. So just like I kind of went in order here of what happened, what the contract was for, when he was supposed to do the work, what work he did, when the change order happened, all this in the list here, those are things that John's going to have to go through when he gets to trial. So he wants to make sure that he's got all that properly recorded for himself, that all the records are in a good chronological order, so that when he's detailing what happened with the judge, he's not kind of all over the place. He's really giving it to the judge methodically with dates and relevant information to go along with his narrative that he's going to give the judge. Okay, so that's the chronology, and it's very important because if a judge finds himself or herself confused, then there's a good chance you're going to lose the judge midway through the trial, and you never want to lose the judge. If the judge starts falling asleep or losing patience, that's typically not a good sign. So chronology is very important to be aware of the various dates that you had agreed to with the party. Now, the other thing I jotted down here, of course, is the amount. And in this case, again, as I laid out for you, the initial amount was for $5,000, but there was also a change order for $2,000. Now, part of the trouble here for John's Construction potentially is that, as I mentioned earlier, the change order was not solidified in a contract. It was only done through text messages. So that, again, as I said before, that doesn't mean that not all hope is lost, but that means that John has to ensure to have those text messages for the trial, because that can be super crucial in order to prove that there were change orders. If John just goes into trial and says, oh yeah, we agreed to change the amount for another $2,000 because Jim wanted a different wood used for the patio, judges have the discretion to rely on verbal testimony of a party if they want, but it's that much stronger if John can bring receipts, so to speak, could back up what he's saying with those text messages. So that's why it becomes very important to be aware of all the evidence that you have, whether it's the actual contract, a specific change order, text messages, etc. Okay. And finally, we have the idea of disproving the defendant, which I talked about in the last video and applied to here. So how could John, John knows that Jim Smith is denying that he has to pay John anything because of that email. And that actually helps John because Jim has already given a sense of what his position is going to be at trial. Jim has said that he had to hire another contractor to undo the shoddy work that John had done. So John knows that he's got to disprove what the defendant is saying. And how is he going to do that? Well, number one, he's got the photos, okay, that he took hopefully before and certainly after completion of the work to be able to show the judge, hey, this is the work I did. Does this look like shoddy work to you? Of course, photographs, especially in this day and age with AI, etc., can be manipulated. And it's not always necessarily so that the judge is going to take those photographs at face value, but it's certainly better than nothing. Okay, so it just gives the judge one more bit of ammo, or it's one more bit of ammo for John's Construction to use to allow the judge to be able to believe him. Okay, it adds to the believability. Okay, something I didn't jot down here, but of course, if John has employees, one can argue that they're biased because they're working for John, but that could be up to the judge to decide if he believes the employees or not. So having employees to testify as witnesses could also be very important for John to be able to prove that he did very good and strong work. And finally, as I mentioned earlier, John had the foresight to get Sarah's engineering involved and is going to ask Sarah to testify. Of course, it really depends on the relationship that John has with Sarah. And for the defendant, again, if they do have that relationship, the defendant could try and poke holes into John's expert witness, if you will, as Sarah being an expert, because he can say that there's a bias there. They work together all the time. And he can also question her expertise. And that's getting a bit down the rabbit hole. Not in every small claims court are you going to start getting into cross-examining expert witnesses and their credentials and disproving the fact that they're experts, but it does happen. And in most small claims court, that is within your right to demonstrate whether or not somebody's an expert to the judge. But in any case, we're looking at this from John's Construction's perspective and not the defendant's perspective. I definitely will be doing videos in the future about how a defendant could defend against claims like this. Although you can kind of take it as a corollary to what I'm saying, you kind of sort of reverse engineer it. But in any case, I definitely intend on giving a perspective from the defendant's perspective. But here we have John knowing that he's got to disprove the defendant. And by doing that, he wants to have Sarah from Sarah's engineering to testify on his behalf. So that pretty much sums it up. I've tried to keep the example here as simple as possible. I did kind of go down the rabbit hole of various twists and turns that a case could take. That's a hazard of the profession. I did this for so long. I have enough experience to know that things could take all sorts of twists and turns. But in taking the case on its simple terms, just to wrap up, you've got here a contract between the two parties. So based on that, you look at who the contract was with, and that's how you name the defendant. You've got here the chronology that you want to go through. So you want to make sure from John's perspective that he's got everything, all his ducks in order, and literally in order, so that he can go through it with the judge to make sure the judge understands exactly what transpired and when. You've got the amount, and the amount is kind of in question because you do have the initial contract calling for $5,000, but then there's the change order where it wasn't solidified in a contract, but it was via text message. So that's something that John would want to rely on as well to help bolster his case. And finally, you've got disproving what the defendant is going to say. And John would do that via photographs that he took, via expert witnesses, whether it's Sarah's Engineering, or regular witnesses, whether those are employees, as well as the emails that he may have exchanged with Jim and things that Jim may have said. I didn't say this before, but just thinking out loud, things that Jim may have said in those emails that John could maybe poke holes in. But that's essentially a summary of how John's Construction will be building that winning case using the evidence that he has to win in small claims court. So I hope you found that video helpful. Once again, if you would like me to do a kind of tutorial like that on maybe a case that you're dealing with, feel free to leave that in the comments below, recognizing that it will not constitute specific legal advice. But if I find it interesting and compelling enough and something that I feel comes up for a lot of you viewers, then I may just do a video on it. Once again, thank you for visiting. Please hit that subscribe button, notification bell so you don't miss a future video. Leave comments, share this with maybe somebody, maybe you have a friend or colleague who's going through a small claims court lawsuit and you feel that this could help him or her. And until next time, I'm looking forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.